presentation forever. And more importantly, for our members who may not be able to join us today on this webinar. So we'll get started. Welcome to day 3000 of the pandemic. My name is Mark Castiglione. I'm one of your hosts today, and I'm also honored to serve as the president of the New York Upstate chapter of the American Planning Association. I'll be joined today by my colleague, Rima Samia, to moderate today's session titled Some Complex Issues in Planning and Zoning Decision-Making. I wanted to specifically point out Rima and her work as the chair of the conference committee's session committee. She and her committee were responsible to put together and to pull together the 21 sessions that were featured in this year's virtual conference. Virtual conference like this is not something that we've ever done before, and I'd like to commend the conference committee and the session committee for doing a tremendous job in putting together a compelling series of webinars for our members to enjoy and to learn from. Before we get started, I'd like to particularly thank our session sponsor, Fisher Associates. Fisher has been providing comprehensive professional solutions since 1984, delivering services in transportation, energy, land development, and market research. Check out fisherassociates.com for more information about our sponsor. Without our partners and our sponsors, this virtual conference would not be possible. I also wanted to let you know that all conference sessions are going to be recorded and available through the conference Eventbrite page for at least a year. So you'll be able to log into any sessions that you are not able to attend in person, view those sessions, and claim CM credits for those sessions. So again, we have 21 sessions to choose from. You have plenty of options to secure your CM credits for the next year. A little housekeeping, all attendees are automatically muted. Our speaker, Mark Schackner, encourages questions and believes that audience participation makes the presentation more engaging for the audience and the speaker alike. We would particularly encourage you to submit your questions in the Q&A box, and we will do our best to address questions as they come up. We will want to let the questions to a certain extent shape the content of the presentation, so they're going to be hopefully an important part of the presentation today. To give Mark a sense of the topic areas you will all be interested in, we've included a poll. I'll launch the poll now. Let's launch this poll. And the poll will hopefully help us identify some of the topic areas the attendees are particularly interested in that can be covered in Mark's presentation. So during the remainder of my introductory remarks, I will encourage you to complete the poll and just let us know about the topics you're particularly interested in hearing about. Just an introduction to the session. Planning processes, zoning and planning boards, environmental and development review, open meetings law. These are just a few topics within a practicing planner's purview that are governed by laws or regulations. Whether we're working with elected officials, clients, stakeholders, or the general public, understanding the legal considerations or how to appropriately administer regulations is key to being successful at our work. Today's presentation will cover some complex issues that sometimes cause confusion among board members, the public, and sometimes municipal legal counsel and planners. We will review legal requirements as well as practice tips and practicalities that we should all take into consideration. I'm pleased today to welcome our speaker, Mark Schackner. Mark is his firm's principal municipal and environmental attorney and represents various towns in Warren, Washington, Saratoga, and Essex counties. His practice includes extensive participation in regulatory proceedings before the New York State Department of Environmental Conservation, the Adirondack Park Agency, the Lake George Commission, and others. He is the author of the chapter entitled Environmental Law, New York State Environmental Quality Review Act, in the book of Pitfalls of Practice, published by the New York State Bar Association in 1993 and again in 2002. Mark has lectured extensively about municipal environmental planning and zoning law matters at numerous seminars throughout the state, and is adjunct faculty at Skidmore College, where he's taught the course Environmental Legal Issues in the Environmental Studies program. He also serves as on the board of directors for the New York Planning Federation. Just another bit of housekeeping. The CM credit number for today's session is 9206390. If you're looking, if you want to look it up in the CM search feature on the APA website, just type in the title of the session and you should be able to find it without any problem. So without any further ado, I'd like to turn it over to our session presenter, Mark Schackner, to begin the presentation. I just wanted to relay to Mark, and he may be able to see the results of the poll in the window, but I'll relay them to him verbally now. It's a mixed bag, but I'll list off the most popular ones. The most popular one by far right now is open meetings law and out-of-school communications. The next is the sequence of application reviews when multiple approvals are needed. The third highest is zoning protest petitions. The fourth highest is SEQRA review and EAF completion. And rounding out the top 5 is lawful executive sessions and attorney-client privilege conversations. And the rest are a mixed bag. So hopefully that's helpful to you, Mark.
Extremely so. My turn?
Your turn. I can stop sharing my screen now, and you'll have the floor.
Oh, I also see the survey now for the first time. Before it said host and participants can't vote. So there's our top 5. Open me. Interesting. Good morning, everybody. Mark, thank you very, very much. Rima, thank you as well. Thank the American Planning Association for the opportunity. Out of curiosity, I'm wondering where we are in the hit parade of 21 presentations, but you can tell me that later. As Mark said, I'm Mark Schackner. He relayed some of my current professional status. I'm actually no longer an adjunct professor at Skidmore College. I did that for 10 years and then felt I had done enough. Basically, I am an attorney in private practice in Glens Falls near Lake George. I am, as Mark said, an environmental and municipal attorney with a concentration in planning and zoning. I've been doing what I do for right around 38 years. And in that time, I'm both extremely proud and extremely embarrassed to say that I've been to more than 2,000 nighttime meetings of planning boards, zoning boards of appeals, town boards, city councils, and the like. I've done close to 200, we're closing in on 200 presentations, mostly about planning and zoning, not all about planning and zoning, but mostly about planning and zoning. But like the folks from, like all of you and everybody else, this is new turf for me in terms of doing it virtually. One of the things I pride myself on is the interactiveness of presentations I'm involved in, where I ask people to chime in verbally, and you're not going to be able to do that, and that's fine. We'll struggle through, and hopefully it'll be a worthwhile 90 minutes or so. But it is a little different. I'm not going to spend much time telling you where the fire exits are. I'm not going to tell you whether to smoke cigarettes in the room or not. I'm not going to bother telling you to silence your cell phones. And I'm not going to tell you what to do or not do with your pets from the comforts of your home. I often, actually almost always, take a survey of who the attendees are and who the participants are. And I'm not going to be able to do that either. But in conferring with Mark and looking at the list of people who signed up in advance, we're surmising that about half of the planners in attendance work for some type of governmental entity, a local government, a town, a city, a village, a county, planning entity, a whatever. And roughly half are in private practice, which probably still means you do some work before municipal governmental entities involved in planning and zoning, but not necessarily that you're professionally affiliated with the municipal entities involved in planning and zoning. This is about the speed and the volume that I was planning to speak at. If you have a problem that I'm speaking too rapidly or too quietly, or any of the other permutations of that, please, I guess, type in to Mark as soon as possible, and he will let me know.
Sounds good so far to me, Mark.
Excellent. Thank you, Mark. And as he said, we're going to encourage questions or comments along the way. Obviously, questions or comments that are presumably directly on the topic we're talking about. And Mark and I will exercise some editorial license there, where if we feel like we're getting too bogged down, or a question or comment is not really relevant to what we're talking about at that moment, we may, we may reject it or come back to it later. Couple of things that are different about this morning's presentation from my standpoint, aside from the obvious that we're doing it virtually, is that I think the title is something like Complex Issues in Planning and Zoning, or in Municipal Planning and Zoning. There is not, although I pride myself on the cohesiveness of most of my presentations, there is not cohesiveness to this morning's discussion. There may be coincidental cohesiveness, but it would only be coincidental because by design, what I did was I identified some relatively complicated topics in planning and zoning. Our jumping off point is that the vast majority or all of you are very knowledgeable about local municipal planning and zoning, and we've purposely targeted this discussion to complicated topics that come up that still confuse not just by no means planners only, but actually confuse board members, the public, municipal attorneys such as myself, and planners as well. And that's our focus. Before I forget, I did look at the list and I was kind of surprised at how few I think I know, but my 3 shout outs are to, if they're in attendance, and I'm not asking them to say whether they are or not, but my 3 shout outs are to my former colleague, Wendy, from the western portion of the state, who I haven't seen in a long time, but hello. My local colleague, John, who I haven't seen in a while also, and my northern colleague, Trevor, who I hope is in attendance as well. But the vast majority of you, and this is unusual for me, as I said, I'm closing in on presentation number 200. The vast majority of you don't know me from a hole in the wall, but hopefully we will give you some guidance on kind of 2 lobes of guidance, if you will. One, what you expect, which is technical legal. I'm not really fond of technical legalese. I'm not fond of the notion that many attorneys feel that in order to communicate, they have to speak in a lingo that one must have attended law school to understand. I'm actually pretty resistant of that, as are my colleagues. And the few of you who know me know that I am somewhat legalese averse. There'll be some legalese in our discussion this morning, but one thing I'm very, very anxious to do whenever I do a presentation is give advice and guidance that's not only technically, legally correct, which of course it must be, but is also practical. And you may or may not be surprised to hear that those 2 are not always the same thing. I represent about 24 municipalities, the most rural of which, last I knew, had something in the neighborhood of 400. I used to know the number. It might be 428 full-time permanent residents. And then I represent municipalities in Saratoga County and elsewhere that have, many thousands of residents. The technical legal advice that I give, same as, the Department of State and same as folks in Albany and same as folks that wear 3-piece suits, which I tend not to wear, I can assure you is going to be correct. The practicality of the technical legal advice sometimes runs amok, especially in the smaller the municipality. So for example, if you hear somebody often from Albany, often Natalie attired, say something like, as a planning board or zoning board of appeals member, you must recuse yourself from board consideration of any application if you have ever met or know if you ever before met or know the applicant. That might be helpful advice for the City of Albany Zoning Board of Appeals. That's incredibly unhelpful advice to the municipality with 482 full-time permanent residents, because what would happen is the members would have to recuse themselves one after another. We would never be left with a quorum. We would never be left with an ability to make a decision. So the point of all that was not to talk about voting requirements. The point of all that was to make sure that you appreciate that sometimes I will try to draw a distinction between technical legal advice and the practicality of implementation of that technical legal advice, because it's not always the same. Okay, so if I understood correctly, well, you know what, I see the survey, so let's go with the numbers. Let's talk about the open meetings law and out-of-school communications. The open meetings law, everybody knows what the open meetings law says, and everybody has the same basic understanding of its fundamental premise. And in my experience, which is rather extensive, as I said, I've been around the block many times, this is a classic example of where the understanding of the fundamental premise and the letter of the law doesn't always play out perfectly in real life. But let's make sure we have the same jumping off point. The underlying premise is, of course, of the open meetings law is, of course, that a public body conducting public business must only do so in open public session, in a meeting that's open to the public, hence the name of the law, the open meetings law. Nobody disagrees with that or nobody credibly disagrees with that fundamental premise. You all know that, and we'll actually probably mention briefly a couple of exceptions to that premise, but that's the fundamental premise, and we all understand that. I tell anyone who's willing to listen to me, I say, take that fundamental premise, take its practical implementation aspects, and strive for the highest standard possible, by which I mean strive to do as much in the public eye, in the public meetings as possible, and as little behind closed doors as possible, within reason. You have to say within reason. You all are planners. You are not members of the public body. In other words, you are not yourselves members of a planning board or zoning board of appeals, or if any of you are, you're going to be in a tiny minority. As planners, of course, you don't have to conduct your business at an open meeting, public meeting, other than when you're attending meetings either on behalf of private clients or assisting municipal governmental bodies. You would not be conducting your business at open public meetings. But most of what I'm going to talk about is how the municipal officials that are members of planning boards and zoning boards of appeals should conduct themselves. So the easiest way to abide by the letter of the law, which is public business conducted in open public meetings, and the spirit of the law, which is maximizing transparency, which I'm a huge believer in, is to simply strive to avoid what I call out-of-school communications. And what I mean by out-of-school communications is informal discussions, usually occurring about some pending application or soon-to-be pending application, informal discussions by or among board members themselves, informal discussions with applicants or their representatives, informal discussions with neighbors or the public, and really with anybody, even if the informal discussions out of school are not technically in violation of the open meetings law. I just urge that you avoid out of school discussions, period. So I can't ask for a show of hands, but I know the answer because I've done this many, many, many times. How many of us have been stopped outside of our office and asked some question about some pending application matter before a local planning board or zoning board of appeals? If you work for a municipality, I'll be shocked if that has not happened to you. It's happened to me, and I'm certainly not a voting member of any board. If you are a planner who does not work for a municipality, I'm going to discourage you from, when you run into a board member in a social setting or other setting or in the community or neighborhood, from seeking to confer with them about a matter that you're involved in, because it's not it's not in keeping with the spirit of the open meetings law. It probably doesn't violate the letter of the open meetings law unless you run into a majority of the board members, but it certainly violates the spirit. So the easiest way to make sure that if you are a public official, that you comply with the provisions of the open meetings law is just to avoid just to avoid informal discussions out of school altogether. When they occur, the municipal official is supposed to disclose that they occurred at the next meeting. So in other words, if Joe Blow calls the chairman of the planning board to talk about an application on the phone, the planning board chairperson should try his or her best to duck that call, politely, of course, and say, I'm sorry, but I'm not supposed to discuss these applications out of school.
Hey, Mark, we have a question that came in related to what you're talking about right now. And Jason Haremza put it in the Q&A, but I've also allowed Jason to speak if he wants to ask the question directly now.
Oh, either way would be great.
Oh, thanks, Mark and Mark. So yeah, I recently was working for a small rural municipality as a municipal planner. And one thing we ran into, especially in COVID times, was having sort of, I would share information as a municipal staff with the land use boards by email, but they would reply all and it would turn into sort of an email discussion. And I cautioned them not to do that, but it's working against human nature to try and rein that in. So any thoughts on that?
I do, and thank you for that. It's a perfectly timed question, a very insightful question, and it also involves, the current times we're in. So you have 100%, no, 1,000% correctly identified one of the numerous slippery slopes, and you've identified one of the ones that's a pet peeve of mine, and also a pet peeve of the Committee on Open Government. The Committee on Open Government is a sub-agency of the Department of State. That is what it sounds like. The Committee on Open Government, it issues opinions about largely about open meetings law and freedom of information law issues. Why is this a pet peeve of mine? Why is it a slippery slope? Because of the wonders of email. I myself despise email for many reasons. This is a classic example. When what you described happens, you said a phrase, I can't remember how you put it, but you were right on target. I think you said something like contrary to human nature. And by the way, your cautionary statement to your board was 100% on target. They should not then engage in this email conversation. The Committee on Open Government has labeled that as a virtual meeting. This was before COVID times when we didn't have actual virtual meetings. And that there's no court case, law, rule, or regulation that says that breaks the open meetings law. But it's clear to the Committee on Open Government and clear to me as a practitioner in this area that once that dialogue starts happening on email, it's a virtual meeting, not the kind that's now allowed by executive order, because as we all know, while virtual meetings are now allowed, they're still subject to public notice and public opportunity to participate and or view requirements. What you're describing is exactly what human nature dictates, and that is that the board members then start emailing, fingers flying fast and furious, to create what the Committee on Open Government, again, labeled before COVID times, an inappropriate virtual meeting, so that the public body is in essence conducting public business completely shielded from transparency. So that's a very insightful question and comment. The guidance you gave them was 100% accurate, on target. This is the first of what will likely be several times that I mentioned that while there is not a specific court case yet holding that is an illegal set of communications, I and others believe that when the challenge arises, not if, but when the challenge arises, those type of virtual discussions, because they are not been the subject of public notice and there's been no public opportunity to observe, much less participate, will be deemed unlawful and violative of the open meetings law. So that's our view on that. In this day and age, it's even harder, for obvious reasons that I won't belabor, it's even harder to prevent that sort of discussion from happening. But you have to try to, it may not be the planner's responsibility, it depends how the municipality is structured, but somebody has to try to shut that down as much as possible. Now let's paint with a very fine brush a very important point here. The planner, your communication, and you're all planners, your communications with the board members, those are not those cannot really be fairly deemed violative of the open meetings law, because again, I think I mentioned this hastily a few minutes ago, you are not members of the public body because you are not the decision makers. So there's absolutely nothing wrong with, and in fact, it's to be commended, that you communicate with your board members if you're a municipal planner, and that your board members communicate with you. The slippery slope happens when, of course, you communicate with them more, as a group, and they start then communicating not just with you, but with each other. So the way to tamp that down, if possible, is to have the communications be all from planner to board members, from board members to planners, and then to the extent they're shared, which is fine, discourage in the strongest terms possible, the then occurring dialogue, what you correctly referred to as human nature dialogue among the board members. That's what you have to try to shut down as best you can. So it's very important, especially for you all, that you recognize that since you as planners are not members of the public body, of course it's appropriate for you to communicate with the board members. Between meetings, it's very healthy for a board member to contact planner and say, hey, I'm looking at this site plan. I'm not understanding why the berm is located there. Is it going to work? I'm not understanding the site distance at this intersection, whatever. Totally, totally appropriate and makes for a better planning process. It's also not unlawful for board member A to call or email board member B and ask those same questions or make those same comments. But that clearly violates the spirit of the open meetings law, because that's conducting public business and by the decision makers themselves in a manner that is completely shielded from transparency. So I hope that distinction makes sense, because it's perhaps subtle, but extremely important. You all as planners have a critical, super important role, and you're not subject to the same limitations as board members themselves. So let's, if it makes sense, those are the most important things I would have to say about open meetings law and out-of-school communications. Interestingly, to me, perhaps not to anybody else, but most of the topics that we identified to potentially discuss are themselves the subject of, if not entire courses that I do presentations about, big portions of presentations. So if it's okay, I guess I'll try to keep moving and go to number 2 on the hit parade. And number 2 on the hit parade seems to be, if I'm reading it right, sequence of application reviews when multiple approvals are needed. This is a topic that is, to me, surprisingly misunderstood, but although again, there's a portion of it that where the best practice is not required by law, it's just the best practice. So in short version, sequence of application reviews when multiple approvals are needed runs into some difficulty for either or both of 2 reasons. One is, when a lot of reviews are needed, it just is inherently somewhat complicated. And what happens is the ping pong ball effect, especially in the context of SEQRA review. I'm not going to go into detail at all about what SEQRA is, because we're assuming you all know painfully well what SEQRA, what the acronym stands for and what SEQRA review is all about. But when multiple application reviews are required for a particular application or for a particular project or action, there can be a real ping pong ball bouncing back and forth, issue/problem. Applicants hate this with a passion. If you are a private planner who works with applicants, you may hate this with a passion. We, I guess I'll acknowledge and somewhat feel your pain, but I'm also not incredibly sensitive to it just because of what I do for a living. The specific questions that come up typically are 2, maybe 3, a third one sometimes, but 2 come up pretty frequently. The first one that comes up is, if a particular project or action requires variances from the Zoning Board of Appeals and also Planning Board, subdivision, or site plan review, what should our sequence be? Normally, I would ask those things as questions and ask for people to jump in. The limitation of COVID is such that I will not do that. But the answer is, there is not a legal requirement for ordering that sequence. However, there is a very clear best practice. And the very clear best practice is to go to the Zoning Board of Appeals for variances first, and then to the Planning Board. We'll talk about the complication of how that SEQRA review may complicate that in just a minute, if people want. But the 2 reasons, at least, there may be more, but the at least 2 good reasons for going to the Zoning Board of Appeals first. And by the way, these would be 2 good reasons whether you are a municipal planner or a planner in the private sector working for applicants. The 2 good reasons are, first, that if you don't go to the Zoning Board of Appeals first and you first go to the Planning Board seeking its review and approval of whatever, then the Planning Board is looking at something that at the moment of their consideration is not allowed, right? By definition, it's not allowed, whether it's not allowed because it's too big, too tall, too close to a sideline, a property boundary or whatever, or even worse, whether it's not allowed because it's not an allowed use and the variance that must be sought is a use variance. Either way, you're forcing the Planning Board to review something that, as they sit there reviewing, is not allowed. So there's sort of a philosophical reason not to go Planning Board first if something needs variances. Then there's a more practical reason, and this one I can assure you, if you've not seen this happen, I've seen this happen many, many times, and it is valid. The practical reason is that if an application goes to the Planning Board for approvals first before going to a ZBA, when we all know it needs ZBA variances, and the Planning Board approves the application, that puts a lot of pressure on the Zoning Board of Appeals to also approve the application. And I can tell you, I've seen Zoning Board members be very resentful of that because they felt that the process leapfrogged over them, went to the Planning Board first. Now they feel a lot of pressure to approve something that they feel may not meet the criteria. And especially in the context of needing a use variance, you all likely know that use variance criteria are very, very difficult to meet. And that's why I said it also makes sense from the standpoint if you're a private planner working for private applicants, because if you go through a rigorous planning board review process on something that we know needs a ZBA use variance and then go to the ZBA and the use variance is denied, you've been very, very inefficient in pursuing your goals. And that alone can, be troublesome to your client and to yourself and to whomever. Yes, sir.
Hey, Mark, we have a couple questions coming in. The first one again is from Jason, so I'll let him ask it.
Oh, thanks, Mark and Mark. So Mark, I wanted you touched on an issue I ran into specifically with this is regarding SEQRA and subdivision approvals that also require an area variance. The area variance is often, in my experience, a type 2 action. So if the zoning board goes first, how can they make a decision if the subsequent decision of the planning board to approve the subdivision is unlisted, and therefore SEQRA wouldn't be done until it goes to the planning board? Or does zoning board have to do the SEQRA review in this case? It got very mind-twisting, mind-bending to me when I was wrestling with this.
Yep, and again, rightly so. Again, very insightful, and again, very on point to the complexity of the situation. So and unfortunately, there's not a simple answer to that situation, but here's the answer. Through an anomaly in the SEQRA, in the implementation of the SEQRA regulations, if the area variance from the ZBA is one that could be considered on its own a type 2 action, and you all know that type 2 action means not requiring SEQRA review, then one of the anomalies in implementation of the SEQRA regulations, despite people like me and DEC and others lecturing about don't segment SEQRA review, one of the anomalies of the implementation is if the area variance being sought is one that standing on its own would be a type 2 action, like an individual lot line or setback variance, then the Zoning Board of Appeals can go ahead, review that variance application, and then if it's approved, then the application can proceed to the planning board or to whomever, it might be other agencies as well, for the SEQRA review to then take place, and the zoning board job will have been done. If the Zoning Board of Appeals variance that is sought cannot be legally or appropriately characterized as a type 2 action, then the ping pong game begins. By the way, I don't play ping pong, but I get what people mean when they say that. So that if you, Jason, have not been through this, I can assure you many, many people on this call or on this conference have been through this. And the ping pong game that I'm specifically referring to at this moment is the Zoning Board of Appeals might receive that application, and then, assuming it's not SEQRA type 2, then there are a couple of possibilities. And this is perfect for our discussion because this really is very advanced, very complex SEQRA review. The two possibilities, and some of you likely already know what I'm getting at, are first, that the Zoning Board of Appeals, that the action is an unlisted action, neither a type 2 nor a type 1 action. It's an unlisted action, and therefore it's not subject to coordinated review requirements, and therefore each of the involved agencies will conduct its own SEQRA review of the entire action, not just of the variance, but the entire action. So the Zoning Board of Appeals may have to conduct SEQRA review of the entire action, even though what's before it is just, in my hypothetical example, a little baby variance situation. Let's assume it's a minor area variance. And either way, the Zoning Board of Appeals will have to conduct SEQRA review of the entire action. Now, in my experience, and I guarantee most of your experiences, the Zoning Board of Appeals is not nearly as accustomed to or as familiar with or as necessarily adept at conducting SEQRA review as the planning board. That's almost always true. So let's remember that the fact that an action is, if it was a type 1 action, there has to be coordinated review, there has to be selection of a lead agency, and in 9 out of 10 times, or at least a healthy majority of times, that lead agency in our hypothetical situation, in your real situation, Jason, is going to be the planning board. So the application will be bounced to the planning board for the planning board to conduct SEQRA review, not necessarily to do its subdivision or site plan review, just to conduct SEQRA review. It will then be bounced back to the Zoning Board of Appeals, or it could then be bounced back to the Zoning Board of Appeals for the Zoning Board of Appeals to conduct its variance review. If successful meaning application approved, it will then go back to the planning board for the planning board to conduct its subdivision and or site plan review, having already done SEQRA review. Many people have strenuous objections to this back and forth. I started at the ZBA, I had to go to the planning board, I then had to come back to the ZBA, I then had to go back to the planning board. In the technical legal jargon that I'm somewhat, I think in some circles known for, too bad.
Hey,
That's
Mark,
the-
we
Yes, sir.
have a couple related questions that came in. One first from Molly, which I think you addressed in your recent comments, and then another one from John Steinmetz. And so I don't know if Molly or John want to ask their questions. Molly was in first, so she can
Okay,
ask
let
first.
me interrupt and let me just finish that thought, and then I welcome those two and anybody else. So the end of that thought is people get upset about that back and forth and ping pong ball, but the New York State Environmental Quality Review Act has numerous imperfections, and its interplay with local planning and zoning means that really is the best way to effectuate the proper result in that type of situation. Let's hear the questions in either order.
All right, thanks, Mark. My question is related to the flow of applications, but we've come across several communities where they might have different boards with different powers in terms of final decision over applications. And one that we see that happens a lot where we find there's a lot of issues is in the case where you have related applications. So a special use permit application, which also has a site plan component, where the special use permit final decision lies with the Zoning Board of Appeals, or in some cases, maybe even the actual municipal board. And then site plan review is under final decision by the planning board. Just wondered on your thoughts on how those play together. I think overall, our biggest recommendation has to kind of have one be more advisory in that role, but just wanted to hear your thoughts.
Okay, so as to your last portion of your comment, one can be advisory only if the local legislation allows one to be advisory only. If the local legislation says, and this, by the way, is not unusual, if the local legislation says that in order to pursue project blah, 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 you need a special use permit from, as you said, you're quite correct. People don't realize this, but you're quite correct. Special use permit jurisdiction can lie with actually any of the three boards, the local legislative body or the planning board or the zoning board of appeals. And that's determined not by state law, but by the local legislation. So in your situation, the project requires some type of discretionary approval from the planning board, but also a special use permit from either the ZBA or the town board, village board, or city council, doesn't matter. Similar reasoning would dictate that it makes sense to get the special use permit first before having the planning board do the site plan review. SEQRA law means that somebody's going to have to, either there's going to have to be separate SEQRA review by each involved agency along the way, and that can only happen if it's an unlisted action under SEQRA, or one of the agencies should grab onto it as the lead agency and conduct the SEQRA review that for everybody, and then it can proceed down the road. Remember, one important sub-issue here is that if it's a SEQRA type 1 action, there must be coordinated review, there must be designation of a lead agency, but also remember that if it's an unlisted action, that doesn't mean there can't be coordinated review and designation of one lead agency. In other words, some people think that, I had this happen just literally yesterday, in a nearby county, the planning director thought that if it's an unlisted action, there can't be coordinated review and designation of a lead agency, and that is not correct. If it's type 1 action, there must be. If it's an unlisted action, it could be either way. Uncoordinated, each agency does its own thing, or coordinated, the lead agency grabs on it, does it for everybody. But either way, if the project requires a special use permit and it's not from the same board, then it makes much more sense to get that done first before the other board does whatever its discretionary approval is. And that means SEQRA review has to happen upfront by somebody. And then we had another question from someone else.
Yeah, another question from John, and then I'll follow up with a question from Kristen.
Yeah, hi Mark, how you doing? My question in terms of the site plan review, whether it's done by staff or planning board, and then the ZBA variances you mentioned earlier, I've seen a handful of communities that either do site plan review at the planning board level or with staff, do a preliminary site plan review first, which then sometimes negates some area variances that that would ultimately have had to been considered by the ZBA. So I think that's a really good practice to go preliminary site plan review first, ZBA variances second, and final site plan review third. I just want to get your thoughts on that sequence of events, if that's makes sense to you, or if there's some legal issue with that sequence.
I like how you ended that, because the answer is both. And by both, I mean, it does make sense to me, and there are some legal issues, which is kind of why I'm here, I think. It makes great sense for any number of reasons, not the least of which is the one you identified, which is, I think you said, by doing the preliminary first, you may end up reshaping, massaging, use whatever word you want, in a manner that changes it so that either it doesn't need the variances after all, or it needs less variance. That was sort of what you were saying, right?
Yes, correct.
Right. So for that, among other reasons, I think it makes very good sense. But there's one extremely important pitfall to be wary of in that context, and that is the preliminary really has to be carefully labeled as advisory and non-binding in any fashion, or else because if the preliminary is otherwise, if the preliminary is something that's a formal binding decision, then it can't lawfully be made without doing SEQRA review first. And I am assuming this has to be true, and many communities I work with, by the way, do things like what you're describing. I think that's a very good practice, and I think obviously you don't want to be doing your SEQRA review at that preliminary stage. That goes without saying. So as long as it's properly labeled as non-binding advisory preliminary and cannot be deemed to, and this is sort of the legal jargon, cannot be deemed to constitute a final decision binding on, the applicant, other agencies, et cetera, and committing to a definite future course of action. That's one of the SEQRA lingo phrases, committing to a definite future course of action. So long as it can't be labeled that way, you won't have to do SEQRA review, and it's an excellent practice.
Thank you.
One other question I think is related, and Kristen unfortunately can't ask it herself, but I think this relates to your best practice of identifying, having the preliminary site plan review and then kicking it to the ZBA. But Kristen's question is, oh shit, where did it go? It just disappeared.
That's the wonders of modern
All right,
technology.
here we go. What happens when the applicant receives its area variance approvals from the ZBA, if they start there, and then the planning board asks for site changes causing an alteration to the received area variances?
Okay, so a bunch of you all, I think, know that does happen in real life, and I think a bunch of you all know probably the best answer, and that is that the ping pong game continues. If that happens, and that happens, then an applicant may have to go back to the Zoning Board of Appeals seeking modification of the variances. From my standpoint, and hopefully from most, if not all of your all standpoint, that's the planning process working properly. Is it another board meeting? Sure. Is it another appearance? Sure. But it's the planning process working properly. As a result of planning board massaging, the application was approved in a situation or with a constraint that has to require a change in the variance. You go back to the Zoning Board of Appeals seeking modification of that previously granted variance. That's a healthy result, in my opinion, of the planning process.
We have one other question related to the previous topic about public meetings. If you want to bounce back to that one, or we can go to the next topic, or.
Let's bounce back.
Okay. So this question about public meetings, what is the best practice to incorporate the ability for a board to virtually meet? Is it Zoom, GoToMeeting, et cetera, with the parameters of open meetings law beyond COVID? So this is speculating what's gonna be the role of these virtual meetings after COVID. So the county planning board wants this ability for instances of bad weather, sickness, snowbirds, but if I read the word of the law, how do you get the open meeting the public involvement? It's not practical for a member of the public to show up at my house to join the video conference. Those kinds of issues. So speculating on what's going to be the outcome of, since the genie's out of the bottle with these virtual meetings.
Okay, so I'm not sure how much of that was the question around you, Mark, but it doesn't matter. So here's my response to that. First, it's a multiple part response. The first part of the response is, in one way, I'm the last person to know the answer to that question. And that way is that I am incredibly not technologically savvy. This is quite the exercise for me doing this particular thing virtually, although I've now participated in 100 or so Zoom meetings, counseling boards and the like. This is the first time I'm doing the presentation. Here's my second part of my answer. And this is as much personal as professional. My professional answer to the question is, I haven't the faintest idea. It would require permanent amendments to the open meetings law. That's my attorney/professional answer to the question. That's an easy answer. It would require permanent amendment of the open meetings law so that the virtual meetings could continue in some requirement built in for facilitating public attendance or participation, short of showing up in my living room, because you're absolutely right. You or the questioner, it doesn't matter who, somebody used the word speculation or speculative. What do I speculate? This is the personal/professional part of my answer, and the personal/professional part of my answer is, to my shock, and I cannot overemphasize how shocked I am by this, I see many benefits to conducting public business this way, not the least of which is somebody just said something about the weather, the whatever. I drive many miles per year because my practice is somewhat geographically far flung, going to many meetings, including I live in the North Country, driving on snow and ice, et cetera, et cetera. I won't belabor the point. I believe, but I have no basis for this belief. I believe/hope that the open meetings law will be permanently amended as a result of the COVID crisis. And I believe it will happen in a manner that will allow us to continue to have virtual meetings so long as appropriate measures are made for public participation and attendance. The last part of my answer is, I have absolutely nothing whatsoever to do with any of these virtual technology platforms other than an occasional user. But for what it's worth, Zoom has been incredibly successful in my experiences. That's all I know about it, and that's all I can say.
Thank you, Mark, for sharing your opinion and your advice. We have another question just bouncing back to the previous topic about the ping pong and where the 239M review fits into that sequence. So the question from Amy Fisk, and she's unmuted if she wants to ask the question herself.
She's muted on my screen.
Yes, she's still muted. So
Mark.
Amy, if you want to unmute yourself, you can ask the question.
Mark, her note says that she doesn't have a microphone on her
Oh
computer.
dear, I'm sorry. Thank you, Rima. So her actual question is, where should review by the county planning board fit into the process?
Okay, so you all know that under General Municipal Law, Section 239, M as in Mary, and some other subsections, certain applications have to be reviewed by the county planning board. The answer is that the local body cannot act until it has received its advisory recommendation from the county planning board. There's a ton of misunderstanding about the 239M county planning board referrals, much more so than I expect. First of all, many people believe it's an actual binding decision, which it is not, is a recommendation. Many people are still not aware of the supermajority voting requirement that can be imposed on the local board if the county planning board recommends against approval. And also, there's a lot of misunderstanding about exactly what we're being asked now, which is the timing and the sequence. The law says, and cases about the law say, that the county planning board must receive a quote-unquote full statement, full application. So the answer to the question of when it goes to the county planning board is, assuming it falls within the geographical limitation triggering the county planning board advisory review, the answer is, as soon as the local body has received a full and complete application, it should refer it to the county planning board. That's the easy part. And then you have to remember that the local board cannot act until either having received the county planning board recommendation or the expiration of, I think it's 30 days thereafter. As a practical matter, you should wait for the county planning board recommendation. You should take it seriously, but remember that it is not binding. But that's how it works. The important pitfall here, an important part of my advice is pitfalls, as I've mentioned. One really important pitfall, and this happens pretty frequently to my surprise, the local body will say, we haven't received the county planning board answer back yet. And even if it's in within 30 days, we haven't received the county planning board answer yet because the county planning board meets on the third Thursday and we're meeting on the third Wednesday. It's not meeting till tomorrow night. We're going to approve this application conditioned on county planning board approval. I can't ask for a show of hands for how many have seen that happen. It is not gray area It is flatly illegal to do that. There's no gray area whatsoever. There have been court cases specifically on this topic. They have uniformly held that an approval issued conditioned on county planning board approval is not a lawful approval. Crystal clear. Hey, Mark, I don't any longer have, I have the top 5, but I don't any longer have the percentages. So which one is next on the hit parade in terms of the percentages?
Zoning protest petitions.
Which surprises the heck out of me. That's one that I almost didn't throw on because I thought planners would have no interest in it. So zoning protest petitions is the least known, it's definitely the least known thing on the list. Zoning protest petitions refers to the following situation. As we all know, certain activities require some type of change in zoning, whatever it might be. Zone from residential to commercial, the opposite, zone from something to industrial, tweak, maybe it's not as giant a change as the ones I just mentioned, residential to commercial or vice versa, but maybe it's a tweaking. We currently allow commercial up to 10,000 square feet. Somebody wants to do something at 20,000 square feet, whatever. Plan unit developments, plan development districts, they often go by either name. Those are zoning amendments as well. So, semi-frequently, from time to time, infrequently, depending upon the municipality in which you practice, there's a need to consider a zoning amendment. Zoning amendments are zoning amendments must be reviewed by the legislative body, right? The city council, the village board, or the town board. That's who adopts zoning, that's who enacts zoning. Those are the bodies that have the sole authority to amend zoning. The zoning amendment decision-making process, subject to the exception I'm about to mention, is governed by simple majority requirements, meaning if a town board, village board, or city council, let's assume it's a 5-member board because they almost all are. If a 5-member board is considering an adoption or adoption of a zoning amendment, any zoning amendment, 3 votes does it. If 3 votes, approve the zoning amendment, whatever it might be, that carries the day. The zoning is hereby amended in that fashion. There's at least in my experience, very little known way for people who have concerns about the zoning amendment to trigger a supermajority requirement whereby 4 affirmative votes would be required, not 3. And that's by filing what's called a zoning protest petition. You would never be doing this as a municipal planner. You might be assisting somebody doing this as a private planner. You would be assisting somebody who is opposed to the proposed zoning amendment. So those who are opposed to a proposed zoning amendment under a not so well-known provision of municipal law, if they either own enough land themselves or can gather enough support among those who do own enough land in the aggregate together, they can file a formal zoning protest petition. It has some formal requirements that we're not going to get bogged down in. They can file it with the legislative body. By the way, they can do this up to and including the night of the vote. There's no X number of days before requirement. And if they meet the proper supermajority voting requirement of a zoning protest petition, it will force the legislative amendment to have a 4-person or whatever, majority plus 1, supermajority approval voting requirement. In order to be a valid protest petition, there's some T crossing, there's some I dotting, and then the most important part for you all to think or to know, if you care to know, is essentially it's a 20% requirement, and 20% means 20% ownership of the affected land. Sometimes a body is contemplating zoning amendment, amending somebody's zoning, and it's not their first choice. The property owners themselves, in other words, may be facing a zoning amendment that they themselves are not supportive of. It's the municipality asserting its authority to zone property in a way that the property owners themselves don't want. 20% ownership of the property that is the subject of the rezoning, or 20% of the property that is immediately contiguous, immediately adjacent to the property affected by the proposed rezoning. And that includes, generally deemed to include in court cases, if there's a road in between and your 20% is across the road, you still count as contiguous. In other words, the fact there's a road in between doesn't change that. I'm surprised to see that that's a subject of interest, only because it comes up very, very infrequently. But many years ago, I was involved in a very controversial project in Ulster County that involved a required rezoning. And at that time, not tooting my own horn, but at the time, nobody but me seemed to know about this possibility. And there was a town board affirmative vote in favor of a very controversial rezoning. The vote was 3-2, and the applicant was exultant and was thrilled at getting their rezoning request approved. And I told a whole bunch of people, that's not the case. There was a valid protest petition filed. You had to approve the rezoning by a 4-1 or 5-0 vote, and you didn't do that. So they were in the unenviable position of having done what they thought was an approval, and it was not a legal approval. And the protest petition was, I think it was challenged, if I recall correctly. Yes, I do recall correctly. It was challenged. It was deemed valid. And the court said, yeah, clearly this rezoning is not valid because it was subject to a supermajority requirement. Again, very powerful, but very little known tool in New York State zoning. What's next on the list, Mark?
Well, we have another question about the sequential reviews. If you want to take that, we can.
How many things? We have a top 5, right? We had a top 5
Yep.
that got some nice high numbers, and we've been through 3 of the 5, and it's not yet 1 o'clock. Sure, let's go back. Let's take that question.
Here's the question. I think and I'm just going to read it verbatim. I think the 239M referral question also refers to where it fits in the SEQRA timeframes flowchart. I, along with the original questioner, most likely believe there is a point where the 2 timeframes flowcharts touch. But where is that intersection?
So the only part of the question I don't understand is what the 2 time frame flowcharts are. I am actually the author of one. The DEC SEQRA handbook, I believe, used to have one and probably still does have another. I found DECs incredibly complicated, so I challenged a colleague to help me develop a SEQRA flowchart that fit on one 8.5 by 11 piece of paper and was readable and understandable. But we cheated like crazy. The way we cheated is we took out, and it's relevant to this question, or I wouldn't be saying it. We cheated by taking out the time frames. Once you have to add in the time frames, the chart couldn't be on 8.5 by 11 and readable. Why did we cheat and take away the time frames? Because we're lazy, yeah, but not only because we're lazy. We did it because, in my experience, the SEQRA time frames are almost meaningless. And why I say almost meaningless is because they're what lawyers sometimes call rights without remedies. So in any complicated project, this is my experience. If others have a different experience, that's fine. But in simple projects, the SEQRA review does happen within the timeframes that the SEQRA regulations talk about. In complicated projects, the SEQRA reviews never happen within the timeframes envisioned by the SEQRA regulations and on these various flowcharts. That's why I cheated and took it off. And why is that not a problem that it never happens within those timeframes? Because there's no such thing as default SEQRA approvals, meaning there's no such thing as default SEQRA negative declarations. In the rare, and I mean rare, like 1 out of 1,000 times that somebody has been so upset and offended by failure to comply with SEQRA review timeframes that they have filed legal challenges, the result of the legal challenges will be a court order telling the lead agency, hey, lead agency, we're now in the 3rd year of SEQRA review. The SEQRA regulations say you were supposed to do this within 60 days of a complete application. Do it within 60 days of today. Excuse me. The order of the court is do it within 60 days of today. But it's not. Here's the penalty for failing to have it done in a timely manner. So in my view, the SEQRA timeframes are almost meaningless. And the more direct answer to the question is the SEQRA review really doesn't have a direct impact on the county planning board referral process or vice versa, because the county planning board, remember, is an advisory, non-binding recommendation, not a binding decision. So the county planning board recommendation can be made prior to completion of the SEQRA review, or it can be made after completion of the SEQRA review. The SEQRA review can await the county planning board recommendation or not. There's no inextricable link between the two.
Okay. The next topic, which is related on the hit parade here, is SEQRA review and EAF completion. I know you've talked about this extensively.
Yeah, but let's talk about it more boots on the ground, more graphically. And this would have been the one that I was predicting that would have the most interest among the planners. So I'm glad we're talking about it. some of this is talking about the practicalities. I mean, the legalities as well, but the practicalities also. So I'm guessing that many / most, or possibly even all of you planners have been involved in completion, either review or completion of environmental assessment forms. I'd be surprised if that wasn't the case. So that's why I thought this one was probably one that we should focus on, and I'm glad it made the top 5. Remember that there are some, what am I trying to say? The words fly around fast and furious in SEQRA review. The acronyms, that's what I was trying to say. The acronyms fly fast and furious. We have EIS, as SEQRA itself is an acronym. We have EAFs, and the terminology is very hard not to get bogged down in. We all talk about the environmental assessment forms as the short form and the long form. Believe it or not, the long form is not what that form is called. That form is called the full form, but we still all call them the short form and the long form because, as I said at the beginning, let's allow common sense to intrude once in a while. One's short, one's long. Those are perfectly good names for them. We know that the full / long form must be completed for a type 1 action. We know that the short form can be used for the unlisted action. Remember that the municipality can require the long form even for an unlisted action. It is not required to require the long form for the unlisted action, but it can do so. Let's remember a big misunderstanding, more among lawyers, I hope, than planners, is that, and maybe others, but hopefully not among planners, is that the fact that an action appears on the type 1 list by no means means that it must be the subject of a SEQRA positive declaration, means that it does not mean necessarily that it must be the subject of an environmental impact statement. Taking the broadest brush statement about SEQRA review that I could possibly make, and I think it's important because I think many people kind of forget this broadest brush statement. What SEQRA review is about ultimately is whether a proposed action will or will not have potentially significant adverse environmental impacts and, therefore, whether it does or does not require preparation of an environmental impact statement. That long marble mouth sentence, that's what SEQRA review is about. Many people misunderstand it to think that, oh, if there is, they know the phrase significant adverse environmental impacts, they think, okay, if it has significant adverse environmental impacts, that means the project must be denied. That is not true. It means the project has to be the subject of an environmental impact statement. The result of that environmental impact statement process may or may not be project denial. But A, the fact that something appears on the type 1 list doesn't mean it necessarily has to be the subject of an environmental impact statement. And B, a project or an application that is the subject of an environmental impact statement does not mean it has to be denied. So those are important jumping off points. Now, eyeballing it, and Mark and I did this, and I think we thought that roughly half of you probably work for the public sector, roughly half of you probably work for the private sector. Those of you who work in the public sector are probably more familiar with reviewing environmental assessment forms than creating them. Those of you who work in the private sector are probably more familiar with creating them than reviewing them. Either which way, planners, you all planners have a gigantic role in EAF preparation, but, and this is the important legal point, your role cannot be inflated to where you're making the SEQRA determination. This was made crystal clear very, very early on in court decisions under what at the time was new SEQRA law. Many of us, myself included, I will absolutely lump me into this group, many of us thought, who better to make the SEQRA determination than our expert planners? This is what they know. This is what you all are smart in. I don't know much about these things. Who better to know whether this amount of traffic will have a terrible, disastrous impact? Who better to know whether this type of housing stock will or won't have a horrible impact on our community? Who better to know, fill in the blank with whichever potential impact you want to fill in the blank with. But the beginning of the sentence every time is, who better to know? So again, I'm guilty of this along with many, many decision makers I knew and know still. Let the planners make the determination whether there are potentially significant adverse environmental impacts or not. Let it be the planner's call whether we need to do an environmental impact statement. I hope that that makes sense to all of you. However, the part that might not make sense to all or any of you is courts immediately struck that down as unlawful delegation of SEQRA review responsibilities. So this still comes up all the time. Let's let the planner decide. You all might love it if we could let the planner decide. I know I would strongly prefer if we could let the planners decide, and it's illegal to let the planners decide. Now, it's illegal to let the planners decide. That's not by any means suggesting that it's illegal to let you all have input, and the input can be exhaustive, gigantic, and any other large sounding adjectives you might pick. That input from planners is critical. It's essential to help the decision makers make their decisions. But still to this day, and I don't blame them at all, I would do the same thing if I were a decision maker. Planning board members turn to me and say, look, here's what my planner said. Can't we just go with that? And the answer is, technically speaking, no, we can't just go with that. The decision makers have to exercise their own independent judgment on what you as planners are telling them, whether you're the private planner telling them this on behalf of an applicant or somebody, or whether you're their assistant as a municipal planner. They have to exercise their independent judgment. They can and certainly should place great faith in the guidance you give them as planners, but we can't literally delegate the secret decision-making responsibility to the town, city, village planner because it's illegal, not because it would be a bad idea, but because it's illegal to do so.
And
Let's talk.
Mark, Jason has a quick follow-up question, and then we have another question related to type 1 actions. Jason, you want to ask your question?
Okay, before you do, Jason, if either one is about who prepares the EAF, then don't ask it, I'll get to that. If it's about something else, fire away.
No, it's less of a question, more of an observation. I mean, again, human nature intrudes in this, sort of neat, tidy, legalistic, layout scenario. In that, I'm sitting at a planning board meeting. The planning board's looking at me with the seeker form, trying to make a determination. And what should we do? And I've just found it's a fine line between guiding them versus leading them versus making the determination myself. So I found it to be awkward in my professional experience.
I could not possibly agree more. And by the way, that happens all the time, that awkwardness. Literally, not just about, it happens every month for sure at many, many boards. I'm just going to take a minute to tell you something that, in my opinion, is more awkward yet, and I don't see this as often as I used to, but when I first started practicing my trade, I appeared regularly before a particular planning board and zoning board of appeals in a particular community where I was younger, dumber, and more naive, and the layout of the room was such that the applicant presentations was at one end of the long table, the town attorney sat at the other end of the long table, and the planning board or zoning board of appeals members sat in between. And I would find that the head, so in other words, their heads, this is when I was in, not just in private practice, but working for private applicants, the heads were always turning away from me toward that town attorney and not looking toward me all the time. And come to find out that in that particular municipality, the town attorney was literally telling the town planning board and zoning board of appeals members in the kitchen table area, in the break room is what I'm trying to say, during breaks in the meeting, whether they should approve or deny certain applications. That was wildly inappropriate, and if anybody could prove it was happening, was totally illegal. And he was sitting there like the Roman emperor, thumbs up or thumb down, throw him to the lion, don't throw him to the lion. Totally illegal, totally inappropriate. I'm thankful to say that is no longer the case in any place that I'm familiar with. You're 100% correct. That's exactly right. The most important thing to remember, the way you put it is, you said you sometimes feel like you're leading them. You sometimes feel like you're making the decision. The specific words we're picking here are critical. Lead away. Lead away. Don't lead away so much that anybody can say, hey, wait a minute, the planner's making the decision. It's a slippery, you're absolutely 100% correct. It's a totally slippery, indistinguishable, there is no bright line slope, but you gotta lead as best you can without being fairly deemed to be making their decisions for them. And you can say things like, look, here's what I think, this is my guidance, but you have to exercise your own judgment. And by the way, in 99, or at least hopefully over 90% of the times, the board members are gonna go with your judgment as a planner because you are the expert. Totally appropriate, totally fine. You just have to strive to make clear, especially in the meeting minutes. You know, the meeting minutes can't say the planner said, no, this has no impact, or the planner said, yes, this has an impact. The meeting minutes, if they're at that level of detail, have to say the planner suggested that he or she did not feel there would be likely impact here. It's picky, but it's important.
The next question we have, And I'll just read it. Can you speak more to the ability of a community to identify their own type 1 actions? I know municipalities aren't allowed to remove state designated type 1 actions, but I believe they're able to add to the list.
That's a very insightful question because it's absolutely easy, short answer. Yes, they are. It's extremely rare that they do so. Most municipalities feel very strongly that the SEQRA regulations are complicated enough as is, but it is correct that there's a process. There are a couple of processes envisioned in the SEQRA regulations that very, very few municipalities avail themselves of. One is adding to the type 1 list. You can add to the type 1 list actions that would otherwise be deemed unlisted actions. You cannot add to the type 1 list actions that would otherwise be deemed type 2 actions. And the other one that I'll just throw in, again, almost very seldom done, more so than adding to the type 1 list, but very, very seldom, is the SEQRA regulations have a provision whereby a municipality can designate certain areas of its municipality as what are called critical environmental areas. It's very seldom done, and it's actually done probably less than even it used to be because they took away one of the major teeth of that designation with the SEQRA regulatory amendments of a few years ago. It used to be that if an area was designated as a critical environmental area, that meant that any unlisted action occurring in it automatically got upgraded or downgraded, depending on your perspective, to become a type 1 action. That regulatory provision was eliminated in one of the more recent SEQRA regulation revisions. So now, these are my words, there are way more words in the regulation than what I'm boiling it down to. But now all designation as a critical environmental area really means is that the agency has to take yet a harder look at potential environmental impacts than if it weren't designated a critical environmental area. And those of you who are familiar with the EAF forms know that the EAF forms even include a question about, is the area will the project have any impacts on an area designated as a critical environmental area? That question is hugely misunderstood because most people don't realize that in this context, critical environmental area is a specific regulatory term of art. So they assume it just means, will this action be taking place in an area that we consider environmentally important? And they get bogged down in trying to answer the question, and they do so in a manner that's actually illegal because they're not answering the question correctly. It refers to an officially designated through a regulatory process critical environmental area, not just what we as lay people might call, hey, this does seem to me to be a critical environmental area. So I threw that in because that's the second thing that very few municipalities do. But the answer to the question is, yes, it can be done only for unlisted actions or only for actions that would otherwise be unlisted actions, not for actions that would otherwise be type 2 actions.
And Mark, John has a follow-up question related to staff role and SEQRA reviews.
Yeah, thanks, Mark. Just to follow up on what you talked about before, inappropriate bodies or people executing SEQRA decisions. I know a municipality, I won't say who, that has staff not routinely but consistently all the time doing and finalizing the SEQRA reviews. Is there any loophole or local municipal provision or any state provision that allows that role to be formally designated by the elected officials, or is that just again a legal practice like you mentioned before?
It totally depends on what you mean by finalize and formalize the SEQRA reviews. So we need to look at that with more closely. If by finalize and formalize the SEQRA reviews you mean take what the Planning Board or Zoning Board of Appeals did in its SEQRA review and memorialize it in the form and file it with the Environmental Notice Bulletin and DEC and the other involved agencies or whatever the filing requirements are for that particular action, it's fine for you to finalize and formalize the decision made by the body itself. If by finalize and formalize the decision made by the body itself, you mean something that could be deemed to be the planners made the decision, then that's going back to what I said before, that's not lawful. Let's just talk about the nuts and bolts of that for a minute, and then if it makes sense, we'll try to get to whatever the final topic or two are. The nuts and bolts of that are, if you're a municipal planner, you can certainly, you should review EAF Part 1 that's submitted by an applicant. If the municipality itself is doing something, you may be the entity, you may be the person who fills out EAF Part 1, and that's totally appropriate if the municipality itself is taking the action, is doing something on its own, so to speak. If it's a private entity, then you would be reviewing EAF Part 1. You want to make sure it's complete. You want to make sure it's accurate. EAF Part 1 in an application situation is more the applicant's document than the municipality's document. And as long as it's factually accurate, it's not the place to quarrel with the applicant. EAF Part 1 I'm talking about. Now let's talk about the more important EAF Part 2, the evaluation part of the EAF. The evaluation part of the EAF is not supposed to be completed and technically is not finally completed by an applicant. Now, somebody's going to raise their hand and say, well, we just got an application package, and in that package, the applicant submitted not only EAF Part 1 completed, but they also fully completed EAF Part 2, and guess what? They answered every single question, no or small. Gee, I'm shocked. It is not illegal for an applicant to include in their submission a completed Part 2 as a proposed completed Part 2. But please remember, no matter which side of the fence you're on, no board is bound by the applicant's generosity. If people can see me, I'm putting the word generosity in quotes. No applicant is no board is bound by the applicant's or its consultant's generosity in submitting a proposed completed Part 2. If an applicant, and by the way, and I don't know any board that requires an applicant to submit Part 2 having been completed. I know some boards that get extremely annoyed when the package includes Part 2 completed because they feel like the applicant's being too pushy. I don't know. I don't care. If an applicant wants to do that, that's fine. We attorney types, part of our training is to be pushy. I do know attorneys that as part of their applications for their clients submit completed Part 2s each and every time. As I said, shockingly, every single question is answered no or small. Once in a while, they try to score some points and show their independence, and will even check moderate to large, but then include an explanation of why, even though it's moderate to large, it's not significant enough to warrant preparation of an environmental impact statement. That's fine. There's nothing illegal or wrong about making those suggestions. The important part here is if you're a municipal planner, you guide the board to make its decision. And when that board leans on you too much and it sounds like you're making the decision, you have to resist that or you will cross the line into illegality.
right,
What's next on the list?
The 10-minute mark. The next one is lawful executive sessions and attorney-client privileged conferences.
Okay, and that might take us to the finish line. So let me I'm going to look real quickly and see if there's anything I was dying to talk about that I thought you all would want to hear about. So let's talk about that. And the only other one that it's up to you all. If we have time and you want to talk about site inspections for a minute or two, that struck me as one that planners might be interested in. But the executive session attorney-client privilege one, this is something that I would surmise that few, if any of you, come across. Those of you who work in the private sector, I would surmise, would essentially never come across it. Those of you who work in the public sector, maybe you're at an occasional land use board meeting when somebody talks about, can we discuss this in executive session? So executive session is an exception to the open meetings law, one of several. There are several exceptions. Several grounds for lawfully going into executive session is what I'm trying to say. Most of them would have absolutely nothing to do with planning and zoning in any context. The only one that might occasionally have to do with planning and zoning in a context is if the matter at hand has been the subject of an Article 78 proceeding, a litigation challenge, and the board wants to talk about that situation. That is totally appropriate or lawful to do in executive session. Executive session means behind closed doors, not at the open public meeting. Something that is not appropriate, this is probably the more important thing, not appropriate is when a board says, a board member says, I'm struggling to make the decision as to whether we should approve or deny this application. I see the possibility that we're going to get legally challenged. Let's go talk about this in executive session. That is flatly illegal. Whether they want to talk about it behind closed doors or not, that's their decision-making process that has to be done at an open public meeting. Attorney-client privilege conferences are something that few are aware of the ability to go into, including lawyers in our experience, surprisingly few. But if legal issues arise, if legal issues exist, and a municipal body wants to confer with its legal counsel about those legal issues, a municipal body can do so in what's called an attorney-client privilege conference. That conference is not executive session. It's real similar to a layperson. It's going to look, smell, and sound the same because it's a conference behind closed doors. But it's not an executive session that has to fall within one of the, I think it's 8 executive session opportunities. An attorney-client privilege conference is not subject to the open meetings law to begin with. It's not an exception to the open meetings law. It's not subject to the open meetings law to begin with, a very fine and difficult to explain distinction. The reason, I'm not going to go into the ancient history of it, but there's a certain sanctity attached to an attorney-client privilege. So if I'm your attorney and you're my client, anything you tell me is privileged, it's secret, it's confidential, unless you tell me to not treat it that way. And the sanctity of that attorney-client privilege has led to statutes that say that attorney-client privilege conferences are not subject to the open meetings law. What that means is that so long as the board is seeking and gaining legal advice, but it has to be seeking and gaining legal advice, that's critical. You can't use this as a pretense or an excuse. As long as the board is seeking or gaining legal advice, it can meet with me or some other municipal counsel, legal counsel, anytime, any place, anywhere. It's not subject to public notice. It doesn't have to be at town, city, or village hall. It doesn't have, there's no requirement that we open it up to others. In fact, it would defeat the purpose of it to open it up to others. That can happen anytime, any place, anywhere. But you have to religiously observe that the board, that the body/board is seeking and gaining legal advice, not using it as a pretense. In my job, that gets very troublesome. And I have had to say to municipal bodies on more than a dozen occasions, excuse me for interrupting. I'm sorry. You're now crossing the line. You're no longer seeking and gaining my legal advice. You're deliberating about the application, and I can't condone that because that's not lawful. I don't think there, and the last and most important thing, perhaps from the selfish planner perspective, I can say about that is it is perfectly lawful for the municipal body to include you, meaning include its planner, in an executive session discussion about an Article 78 challenge or in an attorney-client privilege conference about whatever planning zoning issue they're talking about. They can invite the planner in, not a problem. Is there what's next on the list, Mark? Or did we run through it all?
No, I just had myself on mute again. Next on the list with 39% is FOIL and advancing technology.
All right, so I already admitted to some of my weaknesses about advancing technology. I guess what I'll say in short, I'll say something generic, short version, and then something more specific to your role, your meeting planners. The generic I'll say is you already heard me say some nasty things about email. I don't remember exactly what I said, but if I've been talking this long, it's not possible that I wouldn't have said nasty things about email. Email can be public records. Public records are generally subject to disclosure under the Freedom of Information Law. 20 years ago, nobody worried about email because we didn't do email 20 years ago. At least I don't think we did. So public record requests were met, FOIL requests were met by the clerk of the board or the clerk of the town, city, or village, gathering together the physical pieces of paper that constituted the records for whatever it is the person was asking about, and then got them to that person asking for those records in pursuit of their FOIL request, Freedom of Information Law request. Email counts as public records. Now, town, village, and city clerks and planning and zoning clerks are being paralyzed by a FOIL request for each and every piece of correspondence pertaining to the blah, blah, blah application, if blah, blah, blah is a large controversial project. Most of the emails back and forth are public records subject to disclosure. That will often include emails that planners generate. It will 100% of the time include emails that outside planners send to the municipality. Those will always be deemed public records subject to disclosure. It may or may not include emails generated internally by the municipality's own planner. That will depend on the context of the email, what it says, and the like. If it's data and certain objective, objective factual information, it will be subject to disclosure. If it's not, it may not be. I think as a practical matter, at least in my experience, the most important thing to think about here is those of you who do work for, municipalities, you frequently create what we sometimes call staff notes or staff reviews or planning notes or planner reviews, whatever you call them, doesn't matter. Just keep in mind, and I think most municipalities do make those available to the public as part of the application package. But keep in mind that that's not a place you want to put deep, dark secrets, because it likely would be subject to disclosure to the applicant, to the applicant's team, to John and Jane Q. Public, and to anybody else, whoever wants them. Should I talk about site inspection just because I feel like it, or should we take whatever's next on the list, Mark? It's your call.
Well, we have 2 minutes left in the session. So if you want to quickly touch on site inspection, that would be fine.
I will, and the reason I thought I would is because often planners have a role in site inspections. Site inspections, hugely misunderstood 10, 15, 20 years ago, less misunderstood now, but still sometimes. Some people occasionally, not often, still think any of the following things. They think, oh, you can't go visit the site because it's not an open, because you're not in your open public meeting. They think a board member can visit a site, but it has to be only one board member, cannot be more than one at a time. Some people think more than one can visit the site and do the site inspection, but it can't be so many that it constitutes a quorum of the board. And lastly, some people think as many board members as wish can visit the site, but if it is a quorum or more, it has to be considered an open public meeting. Those 4 statements have something that I hope is somewhat obvious in common. What do they have in common? All those 4 statements are dead. Each and every one of those 4 statements is dead wrong. So what's the right about it? And then we can wrap up. What's right about it is site inspections are perfectly allowed. They are not required. I think I know one municipality that actually does require them by local legislation, but they're certainly not required by state law. Do I think site inspections are a good thing or a bad thing? I think they're an incredibly good thing. I myself get very little out of looking at the plans as compared with visiting the site. They are not required, even if all the board members go, and even if they go en masse as a formal sort of a caravan proceeding. I know municipalities that drag them all out together in a van with a schedule. We're doing site inspections on the 2nd Thursday of the month from 10 to noon. And here's our list of this week's site inspections. That does not mean they have to be open public meetings. There are many reasons that it would not be a good idea to make them open public meetings. I won't go through them, but trust me, there are. What's your role in that as a planner? If you're the municipal planner, in my experience, you are likely to be the tour guide for the site inspection, and that's totally appropriate. Site inspection, you can point out, you're the planner, you're not the decision maker. You have no constraints on what you can say at the site inspection. You can describe what people are seeing, help them walk around, help them know what's going on. The board members themselves are not supposed to engage in substantive deliberation discussions at the site inspection. I'm sort of fond of some of the things Jason has said, some of the phrases he's used. That's a classic slippery slope, easy to say what the law is, hard to religiously comply with it. Board members are not supposed to engage in substantive deliberative discussions at the site inspection. Does that mean they have to go out there and can't say a word? They're zip-tied their mouths shut? No, it does not. They can ask questions to enhance their information, but they're not supposed to then engage in discussions. Incredibly slippery slope. If you're the planner, for a private entity, when boards do site inspections, whether they're announced ahead of time or not, an astonishingly coincidental thing happens. And what is that astonishingly coincidental thing that happens? Somebody from the applicant happens to be there. An amazing coincidence. When the applicant himself, herself, itself, or an agent of the applicant happens to be there, they never observe any rules about anything. They try to sell the project to the board. They try to explain why, don't be silly, there's no lack of sight distance. I can see a country mile from that intersection. Look at this berm. This is not only a nice berm, will be the finest berm ever constructed in the continental United States. You can hear these statements if you must, but really you should try to not listen, try to not engage in discussions with the applicant. If you're the planner and the applicant wants to tell you things, they can tell you things, but don't then evaluate them on site, leading to board discussion and deliberation, because that's what we're trying to avoid.
All right. That was a very informative and engaging presentation. I'd just like to thank our speaker, Mark Schackner, for providing our law session for this conference. That concludes our 2020 New York Upstate Chapter virtual conference. This is the last session of the conference. Just like to remind, so you're better cleanup, Mark. You did a great job.
There you go. Excellent. Thanks very much.
Just like to remind our members that you can view all of the sessions that were included in the conference on the Eventbrite page for at least a year. Thanks again. We look forward to more virtual session offerings for our members in the coming months. So thanks again, everyone.
Thank you all. Thanks, Mark and Rima, for having me. Thanks, everybody. Have a great day.